This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
We do have handout materials available to correspond with today's presentation. So go to the ADR Services Inc. website, look for the CLE program page, and it's going to be accessible there on the top of the page under today's presentation information. So you can download a copy of that. One note about the handout, it is going to look a little bit different from the version that our neutrals will be presenting during the presentation today. That we have an abridged version during the presentation just for time purposes. And so that version that you'll download from the website will have some extra information that you'll find valuable and more enlightening that they'll mention, but maybe won't cover completely during the verbal conversation. So without much further ado, I'm going to go ahead and initiate our PowerPoint presentation. Today's presentation is entitled, You Can Choose Your Friends, but You Can't Choose Your Family. Probate Dispute Resolution and the neutrals at ADR Services Inc. are here to help. Today's presenters are going to be Ms. Bette Epstein, mediator, referee, and arbitrator here with ADR Services Inc., Judge Barbara Johnson, Judge Mary Fingal Schulte, and Judge Marshall Whitley, all who have extensive experience in trust and estate disputes, and we're very much looking forward to hearing from them today. To go through our agenda briefly, each of our panelists will be speaking on a specific topic for about 10 to 15 minutes. We'll have a little bit of discussion in between, and then at the end, we'll open the conversation up for discussion between the 4 of them and question and answers. So first we'll have Judge Schulte speaking on 638 and 639 references, private trials in probate and trust matters. Judge Johnson will speak on preparation for mediation. Bette Epstein will speak on timing of mediation and who should attend the session and the role of the attorney in the mediation. And then Judge Whitley will speak on the court's authority to order mediation in probate matters. Without any further ado, I'd like to hand it over to Judge Schulte.
Good afternoon. I have a 2 to 3 hour discussion on references and private trials and 10 to 15 minutes in which to give it. So my goal for all of you this afternoon is to acquaint you with options for the various private trials and references that are available out there. Imagine, if you will, being able to choose your decision maker. Tailor-made to your case. Imagine again having reliable trial dates. You have an 8-day trial and you're not trailing day to day, and then you're not being put on the civil trailing list where nobody will pick up your case, and then your case is continued and continued. But having an 8-day trial and getting it heard in 8 days, setting it with date certain. Imagine also having specialized attention with your decision maker. Imagine calling the clerk of the court where you're at on your particular case and saying, you know, we just want about 10 minutes of the judge's time. We just have this little issue that's come up in discovery. We don't want to do motions. That's not going to happen. But imagine having that available to you in the private reference. And at the same time, saving your client money. You're spending some money, but you're saving money. So welcome to the world of judicial references, private trials, and judicial references. An efficient and expedient way, in my experience, and based on talking to lawyers, of getting your case resolved. So that's just a little introductory comment. Again, a little bit of speed dating, I suppose, in terms of what we're going to cover in all these topics. So if we'll have the first slide then. The most common type of reference yeah, that's beyond my pay grade, moving the slides. So I'll just say next slide to Katie. The most common type of references probably are under CCP code sections 638 and 639. A 638A reference is what's called a general reference, and 639 and 638B are special references. How do these references come about? Under 638 of the Code of Civil Procedure, an appointment of a referee is made by agreement of the parties or on motion of a party to a written contract or lease, which is still, so there's still an underlying agreement. And then there's sections A and section B. Under section A of 638, the referee is appointed to hear any or all issues and then reports a statement of decision to the judge from which the court came. But that decision of the referee is binding. So the court just signs the judgment, can't modify it or change it. So that's something important to keep in mind. Under 638B, that's actually considered a special reference. So the parties, I don't see those very often, but the parties will still agree because it's under 638. They may agree, you know, let's just take this issue out of the court right now because it's going to take us, you know, every other year to get this resolved. And it might be an issue of an accounting. And there's, as you all know, as practitioners, accountings sometimes also come with petitions to remove, surcharge petitions, and so forth. And maybe the attorneys just want, let's get a quick hearing on the accounting, and then an opinion is sent to the court, and then the court will either adopt it or modify it. So that last sentence says, court may adopt or reject the referee's statement. The court may also modify it. But again, it's not on the slide, but if it's a 638A reference, the court must accept the decision. It's binding. And I will say that I don't think that the courts very often will reject the recommendation of a referee. Next slide. I know there's probably going to be a lot of questions. I've got covering a lot. Referee, how's a referee selected? Either the parties agree or the court will directly pick someone, which I think is really rare because it just doesn't look too good if the court's always picking a certain person to be referee. Parties can submit lists of names to one another and do a striking procedure, or they can't decide, and so the court will pick from a list of names. On references, disclosures are required, and I'm giving that mostly for your information, just so you know, because you'll start getting a lot of paperwork from, for example, our company, but our case managers will handle the disclosure statements. Type of assignments under these references of 638 and also 639 might be law in motion, might be discovery or specific subsets of discovery motions, maybe presiding over depositions. I've had to preside over a couple of them, and it's because attorneys can't get along, which isn't usually the case in probate. I had one where the attorney had to call the police to get the other attorney out of her office. So, you know, that. And then there's trials by reference, and that's the 638A. So that's a trial, just like you're in the courthouse, and the referee makes a decision, and it's binding and it's appealable. Under the various references, and by the way, I've given you, and it's not the slides we're showing, but within your materials, I've given you all the rules of court and all of the CCP sections that will flesh this stuff out for you. But the referee will either submit a report and recommendation to the court to adopt or modify or reject, or the referee issues a final decision. And again, it depends on the kind of assignment. The rules of court slides that we won't be showing cover all the information about documentation having to be filed with the court, because it's still a court, it's an ancillary court proceeding. So the documents must be filed with the court and in the court file. Next slide, Katie. CCP 639A is the type of reference where the parties don't consent to a reference, or maybe one does, but the other doesn't. So the court can, on written notice of a party or on its own motion, appoint a referee. And I've had both of those happen. What kind of references are the 639A? Where there's an accounting. And I'm seeing more of those, because who knows a trial judge or a probate judge that just loves to do accountings, that lives for accounting. So I'm seeing those get sent out. And then the referee makes a recommendation and the court will adopt or modify or reject it. Another reference, complicated and lengthy discovery disputes where there's a lot of law in motion, very voluminous. That's a common 639A reference. The same procedure for 639 with appointment is done as with 638. The 643 deadlines, I mentioned that, and I always put it in my reports because the referee has 20 days from when it's submitted to make the recommendation or the statement of decision. Then the attorneys need to know, if you object, you have 10 days to object. If you wait too long, you're stuck. And then after there's objections, the other side has 10 days to respond, and the court may or may not have a hearing on those objections. Next slide, Katie. On a 639A, and also this is subsection C of 639, when a referee is appointed in a discovery matter, the order must indicate whether the referee is being appointed for all discovery purposes in the action or for limited, because there's a lot of things that happen in discovery. Maybe the referee is only appointed to hear depositions and rule on objections, or maybe certain types of discovery motions. Maybe there's going to be a carve out for terminating sanctions that the judge assigned to it wants to hear that. So the order has to specify. Next slide, Katie. There's a typo here. It should be 639 D. All appointments of referees pursuant to this section must be by written order and include the information found on the judicial council forms, which is one of the handouts you have. And so it has to state the reason for the reference. I'm too busy, I'm not interested in this is not a good enough reason for the trial court to send it over. So they tailor make their minute orders to specify why it's being sent over, what's the subject matter, name of referee, hourly rate, and whether one side or the other has to pay for the reference. So it's pretty self-explanatory, and I really encourage the attorneys to make sure they get those forms filled out correctly, because I've gotten some references where it's pretty vague what I'm supposed to do. Next slide. Whizzing along. I've got my little timer here. So this is part of your handouts, the Judicial Council Form ADR 109 and 110, and they're great. So that I won't walk you through it because they're real self-explanatory. So those you use. I've also provided two handouts, handouts 2 and 3, and these are 638 CCP 638 orders appointing me as one of them was special master. That one is still ongoing, and the court's minute order only said I'm to help with trust administration. So we've had some Zoom meetings and we're getting it all resolved in just a matter of a few meetings. And then the other one is to appoint me to make a recommendation regarding a trust accounting. So I had a full hearing on that. And then I make a report and a recommendation to the court. Neither of the orders that were submitted by the attorneys said whether it was 638A or B. But the default is if they don't specify, then it's probably going to be an advisory opinion. And actually in the orders that they both wrote up, the language does suggest that it's under 638B because it was for the referee, me, to make a recommendation to the court. But again, if the court or the judge realizes this referee took 5 days to do this accounting and gives a pretty detailed report, not likely to change it too much, but the parties do have the right to make the objections. Okay, we're doing good on time, so let's get to the next slide, Katie. This is one I actually hadn't heard of until I retired and got a reference. Under California Constitution, Article 6, the parties can stipulate that the court hear a trial before a temporary judge. So it doesn't have to be a judge, but it can be an attorney, but you're sitting as a temporary judge. So you have to take the oath of office, like in that picture, which isn't the case in a referee. It's really a similar proceeding to a 638A, but one key difference is the referee is really a temporary judge, and the referee, temporary judge, signs the judgment, whereas under 638, a decision goes to the court to sign the judgment. So I was thinking, well, what's the big difference there? Well, attorneys in mediations are always griping to me about what's going on at court, and I'm not going to go into detail, but one of them had the judge said, you'll get the judgment when you get it. So with this procedure, that judgment is signed by the person that heard your case. And so that kind of moves it along. One little difference, though, is on a Article 6 reference or trial, the temporary judge does have up to 90 days to rule, just like, if it was a bench trial, they have 90 days to rule. Personally, my memory doesn't get better with age, so I try to get them out sooner. But under a 638, they've got to do it within 20 days of submission. The last two slides, these are proceedings I also just found out about in the last couple of years. If you represent a conservator of an estate, handy to know about probate code, and kind of covering two slides at once, but 2405, and then the next one is 2406. If there's a dispute related to the estate between the conservator and a third person, they can enter into an agreement to have a temporary judge hear the case. And I'll give you an example in a minute as I wrap up. And then so the handouts you have for this slide on 2405, and also the next slide has the actual language. I just photocopied the probate code. And then there's a sample stipulation for one of these proceedings. And I think that's your fifth handout. The case I had, just to give you an example of how this can come out. So there was a non-court supervised trust, and the trustee wanted to distribute. Well, one person was under a conservatorship of the estate, and they didn't want to wait like a year or two for an accounting. I mean, the courts are really backed up. So they stipulated to this procedure, and I probably wrapped this up with them, thanks to the attorney's hard work, in less than 2 hours of time over the course of a couple months. They talked and they worked out the accounting issues, and I signed it, approved the accounting. I mean, I don't know about your county. My county here in Orange County, it's just, they're so backed up just getting your first hearing on an accounting. Then finally, probate code, and it's the last slide, 2406. That's another little used section. That's where the conservator can enter into an agreement with the third person. For example, on my last one, if they couldn't have worked it out, they can agree to submit it to arbitration under 1280 of the CCP. You might want to look at those code sections that I attached as handouts, because they do say the court, especially on an arbitration, the court must approve that stipulation. There is a corollary for decedent's estates. It's not in the PowerPoint, so I'll just give you that. That's the corollary to 2405 for a decedent's estate is 9620. And the corollary to probate code 2406 for a decedent's estate is 9621. So there you have it, kind of quick. And if there's questions at the end, I'm happy to hear them. But I think the takeaway is there's just a lot of, I'm not trying to drum up business, by the way, but business is always good, but it gives you a lot of flexibility and a lot of creativity in getting your clients' cases resolved. Because I think all of us that are doing ADR, we really want to help people resolve their cases. And it's frustrating when I hear how long it's taking. So that's my little spiel. I hope I didn't go over too much. I want to just, before we go on to our next speaker, we were going to leave it open if any of my esteemed colleagues have any thoughts or comments, or has anybody done one of these 2406 proceedings, for example, or even 2405 of the probate code. I didn't even know about it till I got mine. Any of you guys?
Well, I'm going to step in only because, but my answer to that question is no. I have not. But I do want to step in to just do a quick insight for lawyers so that they understand what position a court is in when the judge is in the position of making a reference. Yes. Keep in mind that judges take their oath, and we have certain ethical responsibilities to handle all the matters before us and not to kick matters out of court and send them places to be decided by others. So as judges, when you take that bench, and you're assigned cases, you're supposed to handle that case. So we have that feeling of responsibility. We also have the feeling, my gosh, I'd love to be able to send this out and get some help, with some of these things so we can get some of these cases through. So there is a tension that judges sort of exist with on the bench relative to their cases. They don't want to be the judge that's always sending stuff out and not handling their cases and get that reputation. But by the same token, they know that the parties and the lawyers would be better off if they could get these matters resolved and not be subject to this backlog that we have with all of these cases trying to squeeze through. So it's up to lawyers, I think, to request these things, to say, Judge, we would like to have a referral, or we would like for you to do that, to bring it up, to raise it. Because if you raise it, that takes some of the tension down that the judge has, because if the lawyers want it on behalf of their parties, who are the judges to stand in the way? So you sort of open it up and allow the judges to use all of these procedures, that Judge Schulte is talking about, because you're going to have some judges inclined to just use them, pretty easily and aggressively. But you're going to find other judges who tend not to use it so much. And so you sort of need to pry it open a bit. And if you request it, lawyers, and you go on the record, you're requesting it, your parties want it, your clients want it, it takes the pressure off the judges and allows the judges to make these references. And it won't look like the judge is trying to get rid of his or her work so that they can go out and play golf or whatever.
Yeah, that's a good point, Judge Whitley. I actually had a really difficult mediation a few weeks ago, and the attorneys came in with, this is probably not going to resolve. It was just so high conflict, family law on steroids. That's what probate is. So the last I heard, they went to court because they had a post-mediation review, and they didn't have authority from their clients to stipulate to a reference, but they said it was a big convoluted accounting. Your Honor, we wouldn't oppose a 639A order. And so that was made. And one other point I wanted to make was the reason that, so on an involuntary reference, so to speak, the court cannot, without the party's consent, order a trial, a trial that's, with a binding decision, and there's case law, and it says that that would be an unlawful delegation of judicial authority. But I agree 100% with Judge Whitley, both, as from the perspective as a neutral, but also having sat on the bench 25% of my career in probate, and then also doing civil trials. It's just better if the lawyers can work out the agreement, and you can be really creative at how, what issues you want decided and so forth. So anyone else? Probably should get on to our next speaker. I have the pleasure of introducing Judge Barbara Johnson, retired from LA Superior Court, who I've only met virtually, and I can't wait to meet her one of these days. She's got a great presentation for you. There you go.
Thank you. Thank you very much. I wanted to, we're going to spend about 10 to 12 minutes on preparing for mediation. And first, you should decide that, in fact, you want to mediate. And there are certainly good reasons for making such a decision. One is the satisfaction that your voice will be heard in mediation. Second, you have more control of the process because you decide the neutral. First of all, you decide the decisions, the issues that you want to have come to resolution. Also, there's a less burden of finances when compared to litigation for trial. I forgot to start my timer. And then lastly, there's this confidentiality, which is very important in mediation. So in preparing for mediation, since most of your clients are unfamiliar with the process, it's a good practice to advise clients on what to expect. And I think we can go to the next slide. I don't know. Yes, next slide. Next one after that. So what you want to discuss is the mediation process and the specific issues that will be thrashed out at the ahead of time with your client. You want to talk about who will be there at the mediation and where will it be? Will it be on Zoom? Will it be in person? Will it be in the mediator's office? Those are things that you need to discuss with your client ahead of time. The next thing is to collect information to develop a negotiation strategy. So just like litigation strategies, you should have a negotiation strategy. You should have a mediation strategy in the hopes of coming to a solution that both of you can agree on. You should discuss with your client the leverage points that you want to make in mediation. You have to remember that some mediators are not experts in certain fields like IP or real estate or taxes. And so you want to make sure that you identify those leverage points. And we're going to talk about the mediation brief in a minute with your client and how you want to proceed in the mediation. You want to focus on your clients with your client about what you think would be a good result. And you want to come to thinking about results as one that gives you, in the end, closure and peace in the decisions that you're going to make. You should know your mediator and share your goals with them. You should know ahead of time the consequences that you want from the settlement. And you should be open and share with your mediator what your goals are. This is not a time to be secretive about the process or what you want to happen in the end. And then you want to emphasize calm. You should recognize as the lawyer and let your client recognize also that that the goal is not to add wood to a burning fire. The goal is to emphasize calm and let your client know here at this point that the mediation is likely to be long and tedious. Most mediators start, 4 hours and go from there. But you should let them know that the mediator is a neutral. They are not a judge, and that it can be emotionally draining at some times, and there'll be breaks in between. And so they should likely bring a book or something when the mediator is, so to speak, not in the room that you're also in. Next slide, please. A good preparation includes discussing the issues ahead of time with the opposing side's lawyer, and prepare a short list of reasonable demands. So you can discuss with them the objective standards, next slide please, that you agree on that might help resolve the dispute. Does each side have information that they need to process with the mediator? Example is, has the value of the property that you're talking about gone up or down? Has there come to light something that maybe the other party, that another party might be responsible for it? So you want to talk about the issues ahead of time with the opposing side's lawyer. And the emphasis is on reasonable. I don't know if you're on the same slide or not, but the emphasis is on reasonableness. It should include a range of what you think your opening offer will be and what will be a deal breaker. And then keep in mind that the things are likely to change as the mediation process goes on. But at least you and your client have a ballpark figure when you go into mediation. Next, you want to talk about the pre-mediation conference with the mediator. And most mediators have pre-mediation conferences. And these conferences are where the attorney, and if the attorney wants to, the client can be present to talk about, to ferret out any issues that might be needed in coming to a resolution in this case. The questions you should ask in these pre-mediation conferences are whether or not the parties are going to be separated, whether or not they're going to ever have any face-to-face meetings. And also it helps, and we're going to talk about in a minute, about a brief that has been forwarded to each counsel. And so this is a time to let the mediator know whether there's any lingering ill feelings, or if the parties know anything that they want to reveal either outside the presence of their client, if their client isn't with the attorney, or whether or not the client has something to say to the mediator. And it gives, last but not least, an idea of beginning to build some trust with the mediator, and getting to know the mediator, and getting acquainted with the mediator. So you want to have a pre-mediation conference. And usually the mediator sets that up with a time that you can be called, or and talk about some issues that you don't really want to bring up, either that you won't want to bring up in front of your client at the mediation, or that you want to discuss that can help speed the process that the mediator may not be aware of from your brief. And then you want to prepare a mediation brief. The mediation brief is key, and it's a part of the preparation. And briefs should be succinct, excuse me. They should look at the disputed facts and the undisputed facts, the case law, and if there are any prior court orders, and the settlement range or that is available to them. The brief should outline the position of the parties. And this way, the other party, who will likely also brief, can know where you stand if you haven't had any conversations before. But the most important about these briefs is that you shouldn't be so secretive or closed-mouthed about them, because the briefs are likely going to be ordered to be exchanged between the parties by the mediator. And if there's something in the brief that you don't really want the other side to know, because this is your one point that's going to blow the whole case out of the water to make them settle, then you should at least file a redacted brief with the other party. But more than likely, we want everything out in the open. It's confidential. If there's some confidential, something that you don't want, as I said, to be noted, then of course, file a redacted brief. But again, the mediator is likely to tell you to exchange your brief with the other side, so that we can at least start the process knowing what each party's leverage is in the case. And so most briefs, I think, not excluding exhibits, and again, you don't want too many exhibits, but the most crucial exhibits should be between 5 and 10 pages at the most, a mediation brief. So next slide is that we should prepare for settlement alternatives. Well, what do you mean by that? I mean that think about offers that don't necessarily involve finite dollars. You ask yourself, would it settle if there were payments over a period of time, for example? Would it settle? You ask yourself these questions. Would it settle if there could be some type of exchange of properties? Would it settle if there were attorney fees waivers, or each side would bear their own cost in attorney's fees? And is there a possibility of the businesses, if there is a business, or if there's a phrase in the will or the trust that could be exchanged or somehow made more palatable to the other side? The thing is that you want to think creatively. So you want to keep an open mind always through the mediation process, because it goes up and down, and you have to discuss with the other side, sometimes or mostly with the mediator, on what your must-haves are and what interests you're willing to give up. And so that's how you prepare, because you have to, if you're confident in your case, then it's easy to prepare. It's easy to discuss some alternatives available. And in those discussions, We want to consider business and family relationships. Well, as an example, is this just one of many business cases involving the same parties that are that necessitate a continuing relationship? You don't, if you're in business, you don't want to give up. You don't want to give up this business relationship because you might have to see this person again, and you probably will, and it's probably monetarily beneficial to both parties in this case. So you want to think about alternatives that can be made besides this one ask or this $1 million that you want to settle for. Is there some other way that you can do this that the other party can accommodate? And then in family relationships, as of course in probate, there are often family relationships. Is there something that can be said or done? For instance, in some cases, and I've had this, maybe all the other party wants is an apology. Maybe all the other party wants is to say they're to the other party. And because of litigation, they have not been able to do that because they've been separated by the litigation. But by simply allowing the parties to say their piece, that might be an alternative way to settle. And certainly can be involved in mediation, one, because it's confidential. So it can't be used against them in trial or for them in trial. And that's the beauty of mediation, the confidentiality of it. And then if we move on to mindset, I think I'm keeping up within my time and hopefully I'm not talking too fast. Enter the mediation process confident enough in your own understanding of the situation to be open to the other participants' point of view and options that may arise. So coming into and preparing, you should lay aside the litigation mode for a time, and recognize that we don't want to make it any worse than it is before we came into mediation. I tell parties in mediation, look, I'm taking off my judge's hat. I am a judge or was a judge, but I'm taking off that hat. I'm a mediator now, so we want to be neutral. And so we wanted to have the mindset that would leave both parties in the sense that they can be honest openly and they can be courteous because it's confidential, and they both want the same thing, and that is the settlement of the issue. And the last thing that you want to prepare in terms of mediation is the cost. Take a fair estimate ready about the cost of the litigation if the mediation does not settle. You look to the risks that are involved. What are the risks of going to trial? Is there a possibility of a runaway jury verdict? You look at the transactional cost, the time that's involved, the emotional stress that's involved. And so we want to look at the costs in terms of that. And so this is not a public forum for civil litigation, which is a great thing about mediation. That's how you prepare, and that's how you can explain it and approach it, pitch it to your client that because it's confidential, it's not, shouldn't be a long process. And in the end, both sides will come to an agreement. And so I think I'm at my 14 minutes, and I thank you for listening. And now I will introduce you to Bette Epstein, who I have worked before with, and she will present her position. Thank you.
Okay, thank you, Judge Johnson, and good afternoon. So the first question is when to mediate? What's the right time? And in my experience, this ranges from nothing having been filed with the court. There is an issue that's been raised that the parties want to address without court involvement, up to matters being on appeal. I just recently was working on a case in which both sides have appealed the trial court's decisions. So one of the first considerations is the cost of litigation. And how much preparation you need to do before you're ready to mediate. Some attorneys decide that they want to take the most critical depositions first, such as the estate planner in a will contest or a trust contest. or the neurologist in a capacity case, or perhaps only after written discovery has been done, records have been subpoenaed, but no depositions taken. Others choose to do no formal discovery at all. But then the question is whether the parties have enough information to generate and evaluate settlement options. So sometimes this comes up, particularly in accounting disputes, in which either a formal accounting has not been done, information may have been shared, but there's not backup information that has some questions about. So in those cases in particular, when I review the briefs, I often contact trustees, attorney, or estate's attorney to advance, in advance of the mediation, to inquire as to what information may be available prior to or at the mediation. In those cases, it's not unusual that the first few hours of the mediation may involve actually sharing information, because you want the parties to be in a position to make a binding decision. That's a really critical piece that goes into the evaluation of what's the right time to mediate. Another consideration is the relationship of the parties themselves and their tolerance for being in a dispute. Most of these cases involve siblings in dispute, or the second types of relationships we see a lot are step-parents and stepchildren. And so some have a high tolerance for remaining in litigation mode and going through the whole discovery process, getting close to trial. Others don't, that they really want this to come to an end so that they can either grieve for the person who has passed away. And I hear that a lot. I haven't even had a chance to grieve because the litigation or the dispute arose very shortly after the passing. Or they really are making an effort to not destroy entirely the relationship of the parties. So certainly getting to mediation, getting a matter resolved is going to enable the parties to maintain a relationship. There's no right or wrong answer. It's an individual decision that needs to be made by counsel and the respective parties. For those matters on appeal, since we know that the appellate process will likely take somewhere from 18 to 24 months and generate significant attorney's fees, even the side that has received favorable rulings from the trial court may well be motivated to reach a compromise at mediation. Because they've already probably litigated for some year or maybe two or more before they ever get to trial. We're finding that particularly now trials are taking a long time and decisions being made by the judges are taking longer. And so certainly the Court of Appeal process is a lengthy one. And that could be a motivating factor to get to mediation. So next slide, please. So who should attend the mediation? Different mediators have different approaches to this question. From my perspective, anyone who will be helpful to the process and can assist a party in making decisions should be included. So that could be family members who aren't parties to the dispute, friends, trusted advisors. I welcome them so long as they're not disruptive to the process. And if they become disruptive or seem to consume inordinate amounts of time, I can address that during the session. I can either take them aside or have a conversation about their involvement and what's appropriate and what may not be appropriate. I do hear on occasion that a party strenuously objects to a non-party family member, typically an in-law, participating. And I'm glad to have a conversation with whoever is objecting to explain my approach. And I have found that with explanation, they're willing to at least give it a try, knowing that I'm hopefully going to be in control of the situation and that that person isn't going to be a really significant time crunch or factor involved in the discussions. So, but again, my approach generally is that Anyone who can assist the party in making a binding decision on the day of the mediation is welcome. Others who may be helpful to at least be available during the mediation are professionals, accountants, real estate agents or brokers, or medical professionals, either by telephone or now on Zoom. So recently, a family I was working with wanted to consider the appointment of a professional fiduciary to take on a role in the administration of a trust. And we brought everyone together in a Zoom room so they could all participate and meet this person, ask questions, and be in a position to make a decision if this person was appropriate for the task that they were being asked to do. I've also had calls or Zoom meetings with proposed real estate agents to discuss the marketing plan for selling a property. And when there is a professional fiduciary who's serving as a conservator, as a trustee, or a guardian ad litem involved, even though they may not directly be involved in the dispute, I do ask that they be available during the mediation session. I really do want all the necessary parties, as well as perhaps some tangential parties, to help get through the process. So next slide. So let's talk about the role of the attorney in mediation. Judge Johnson talked a little bit about this, and I've got my own thoughts that I wanted to share. So the role of the attorney is first to educate the mediator about the facts and the law, as well as to tell the client's story. Hopefully, they can do so without being verbose or highly inflammatory, at least in the briefs are shared. And I encourage counsel to share their briefs with each other, but I also welcome a separate brief or a letter that is not shared. And that gives the party an opportunity to tell me all of the bad stuff about the opposing side, anything that they want me to know. And I find that highly inflammatory statements about opposing parties or about counsel in a shared brief often result, particularly with the parties, in having to spend considerable time talking that party off the ledge to get them to actually engage in the mediation process, because they get so offended by the statements that were made and fixated on them that they can't really focus on the problem at hand. And it's really a distraction. So I don't find it to be a useful exercise. If someone wants me to know the dirt on the other side, we can do that in a pre-mediation conference or during the mediation session. In my mediations, I very rarely have joint sessions. I typically, when we were meeting in person, have everybody in separate rooms. They don't see each other. And certainly in Zoom mediations, which I have done many of during the last 20 months, the parties don't see each other at all. They separate them into breakout rooms with their counsel, unless there's a reason to bring them together, like when I mentioned that we all met with this proposed fiduciary to have a conversation with him. But I'm very glad to listen to the parties. They need to tell me their story. I think that's part of why mediation works, is because they do feel like they have a chance to be heard. And I think that's a very important part of the process. Mediation is also an opportunity for counsel to be creative. And as Judge Johnson mentioned, to think of yourself as a problem solver, as opposed to being an effective advocate. There are certainly times when there are practical barriers to resolution, such as a lack of liquidity in the trust or estate to accomplish a non-pro rata distributions, which the parties may prefer. And I always appreciate it when counsel consider creative approaches to resolving the dispute. And sometimes lawyers can come up with ideas that certainly I never thought of, and I really appreciate when that occurs. Next, what I ask the lawyers and the parties to do is to think positive. So I am the eternal optimist. even when there are times when by the afternoon, I don't see a resolution in the offing. So long as the parties are talking, there's an opportunity to get the matter resolved. And it's often later in the day when there is a breakthrough that results in a change in position and in settlement. So I'm never one to say this case can't be settled. They can all be settled. It may take time, it may take some creativity, and certainly it takes compromise, but they can be resolved. I am also of the view that a fully documented settlement agreement executed by the parties should occur by the end of the mediation session. And sometimes those sessions go very late. I'm generally willing to stay as late as need be to get that done. I'm really opposed to term sheets or memorandum of understandings, as I've seen them take weeks or even months to get an agreement finalized. And both it's costly, it's time consuming, and it's an opportunity for people to change their mind. So my feeling is that parties should come to the mediation session prepared to make a binding decision during that session. I do ask that counsel prepare a pro forma agreement that's shared prior to the mediation to expedite the settlement process. Even then, it can take hours to finalize the agreement. But in my view, that's preferable to assuming that parties will maintain their positions for the next day, the next week, the next month, however long it takes. So recently I was involved in a mediation in which it took 6 hours to reach an agreement. So we were doing well. It was not the end of the day yet, but it took another 4 hours to finalize it. And part of it was because it had a lot of moving parts, and the attorneys wanted to take their time in making sure that it accurately reflected the agreement. But my feeling, it's worth the investment of time to get it done that day. And with DocuSign, we can get signatures on the page in seconds. It's like magic when the fully executed document pops up on the screen as a, quote, completed document. It's very rewarding. So I'm pretty insistent on working as long as it takes to try and get it done during that day. So that's my perspective and the way I approach the mediation process. I welcome comments from any of my colleagues if they have a different view. Otherwise, we will go on to Judge Whitley.
I'd just like to make a quick comment on the matter of attendees. I'm also okay with having attendees, but I don't know if others have had this issue where they don't tell you in advance. You think you have of course, it's different now that we're doing it mostly by Zoom still. You think you have a mediation with maybe one party here and one there, and they show up with a whole host of people. I just think it's nice for the mediator to know in advance. And I probably tend to be a little stricter about not having too many attendees that aren't parties, because often they can be disruptive. And often when it's like experts and so forth, if the goal is to convince me that they're going to win their case, and probably all see that, they come in with mediation in trial mode rather than in settlement mode. So I really liked Bette where you said if they have attendees who will be helpful to the process and helpful to the decision making of the parties. But sometimes I've had them, well, I've got my expert here, he's going to convince you why we're going to win this case.
Actually, I've had the experience of having an expert convince the other side.
Yeah,
and it worked. They don't have to convince me. I'm not the decision maker,
right.
But they have to convince the other side. And there are times when, if they haven't heard from the expert and they want to disclose that person and that person's views, that it can be helpful.
I think
so. I'm flexible. I never know what's going to happen during the course of the day. That's part of the fun of being a mediator.
All an adventure.
Yeah. Judge Whitley has a lot to tell us about.
Well, before we go on, let me just comment here, because I just want to make 2 points, because your topic, as well as Judge Johnson's topic, is just so important and so central to what we are doing full time, and what the lawyers out there are doing too. And one of the things I wanted to just stress to the lawyers, one thing is what I continue to experience sporadically, but it just continues to pop up is, the clients who, when they get into the mediation, they get, at some point, they may say, I just don't like that person in the other room, and I can't stand that person, usually a relative, as you said, in the other room. And in fact, I can't believe what they've said about me. And I would ask, well, where did they say this about you? And of course, invariably, it's a declaration or a petition or objections or something like that. I would hope and ask the lawyers to please sort of explain to their clients that these documents that are filed in court are advocacy pieces. They are intended to speak in aggressive and extreme language. And please explain to your clients that to not take these things personally and allow those things to get in the way of us being sort of conciliatory and open in the mediation process. So that's one thing I would ask lawyers to sort of explain, that these documents that they're reading and that they see, they shouldn't take them so personally. The other thing is the role of the attorney, I think, is just so important in these mediations. They say that lawyers come into these mediations with a halo effect. I mean, that's kind of what it's called. And that's because the client has gone out and hired this person, and the client believes in this person. So the lawyer carries a lot of weight in that mediation. So the lawyer can actually put their thumb on the scale one way or the other. If the lawyer really wants to resolve it and continues to help push the client toward resolution, especially when it gets tough, then I think the client will tend to sort of move in that direction. That's the experience that I've had. So the lawyer just has to continue to realize how important and effective they can be in helping matters come to a resolution, because that's what you're there in mediation for. The only other thing I would throw up is, I just wonder what my colleagues think, and we touch on it, about the remote. Now, I've heard you say things like, kind of, in person and, somewhat remote and all that. I haven't done anything in person myself, frankly, since the COVID thing. I think the remote thing works absolutely wonderfully. To a certain extent, I think it works even better. But I'd like to I just wonder what you think about it, and is it here to stay?
I think I'm a big fan of it. I think it's here to stay. Last summer, right in the middle of all this COVID stuff, I did a 10-day trial. It was a legal malpractice case. They waived jury. It was the 638 reference, I think. And we did it seamlessly by, I think, 10 days over. There were a couple of breaks here and there. I recommended that they get a tech person to do the document sharing. But even since, and I've done a few in person, if people are vaccinated, and it's not a lot of people, I have some guidelines that I tell them, those are mine, those aren't ADR services. But even in those, I think it's here to stay. For example, you have an expert I'm in Santa Ana. You have an expert in Encino that one of the parties only needs for 20 minutes. What's that expert going to charge to come out there? Half a day, at least $5,000. And so I've done witnesses by Zoom while the parties are there, the attorneys are there. So I think it's here to stay.
And I agree. And I find one of the things that I find particularly helpful is I oftentimes want to meet with attorneys either individually, outside the presence of their clients, or in groups. And it's so easy to move them in and out of breakout rooms, and much easier than when we're in the office and I have to find a conference room and I have to move people around the office. So I'm hoping that Zoom is really here to stay. I think
My settlement rate's about
technology.
the same, I find.
I think it's a good idea, because I've had one where the client was in New York and one was in LA and one was in Dakota or somewhere around there, and they all signed the DocuSign or had their own signatures on the settlement agreement before that. Even though that there was a 3-hour time difference, the 7 o'clock people in LA is 10 o'clock in New York, but still it worked fine.
Right.
I concur totally in all of that.
Let's get on to Breslin.
Get on to you.
All right, so this segues, into this next session, which, let's see, I call it the Breslin effect, which is the judicial authority to order mediation in probate cases, and a brave new world. Of course, it's a brave new world relative to our remote mediations. But the Breslin effect, is it a brave new world or not? And I want to stay on this slide for a moment here. I want to disclose and just voluntarily let you know that I'm not a mediation purist. In other words, I just want you to know from the outset that I have long believed that it's best for all concerned for the probate judicial officer to have authority to order appropriate cases out to mediation, whether the parties who are participating voluntarily or involuntarily. Now, I'll get a little more into that as we go along, but I'm a believer in that, number one. Number two, this Breslin effect, that as I'm calling it, frankly, when the case came out, which is this year from the Second District Court of Appeal, I think it created a kind of probate euphoria, if there is such a thing. And many of us were pleased when we saw that, because as I indicated, I'm a believer in this anyway. Next, this presentation, however, I will call it a cautionary note. And what I'm suggesting in this presentation is that we temper our enthusiasm with a careful analysis of the Breslin application, which is the or not really part of the brave new world, because there appear to be limitations. And I believe that the timing, may be right to take the guesswork out and to, here it is, wait for it, and to codify the authority that Breslin seems to be giving. Now, let me give you some background here, and I'm not ready for the next slide yet. But let's say when I started as the supervising probate judge in Alameda County in 2003, I believed when I sort of stepped into that court that I had the authority to order cases out to probate. Order cases out to mediation. I certainly, looked for that authority in our codes. I didn't find anything specifically giving me that authority. And I didn't find anything that said I didn't have the authority. So I opted for, well, I must have the authority then. But I was concerned about that because, I'm sitting there, on this island, and I wanted to know what other judges throughout the state thought about it. And as I got more and more involved in statewide judicial probate organizations and having meetings, I would bring the matter up with some of the other judges. And I found that there was a difference of opinion, regarding, this authority. So I was a little concerned about it, and it concerned me a bit. So let's go to the next slide. So apparently it was also of some concern at about that same time, and basically in a couple of years later, by June of 2006, the State Bar Trust and Estates section, the Executive Committee, proposed enabling legislation to authorize, the probate courts to order matters out into mediation. And they came out with a relatively simple and straightforward proposal, which I think bears, focus at this point. And they proposed that a new section, 1051, be adopted, And it basically says three things here. It basically says that the court can order mediation either upon a motion of a party, or secondly, by written stipulation of all parties, or thirdly, upon the court's own motion. So that was in the minds of that text, Trust and Estate Section Executive Committee, apparently after having discussed it quite a bit, and I would presume also discussing it with other lawyers throughout the state, members of the committee. And so they decided to sort of float this proposal. Well, let me go to the next one, the next slide. Now, as you see at the top there, it says timing is everything. Well, it just so happens that at or about that same time, in early 2007, the Court of Appeal decided a case called Geldwin versus Superior Court. Now, this was not a probate case. It was a construction defect case. But basically what this Court of Appeal decision came out and said was what you see in bold there: forcing a party to attend and pay for private mediation over objection was antithetical to the entire concept of mediation being voluntary. In other words, for those purists who believe that mediation should be voluntary in all cases, this was contrary to that. And so Geldwin sort of slapped the hand of the trial court and said, basically, we ought not be doing that. Now, here we have, the Trust and Estate section of the State Bar, trying to sort of indicate that this authority should be given to the probate court, basically to order, be able to order on its own motion. And on the other hand, we've got Geldwin that has come out and said that it should be voluntary, number one, because it tends to work. In fact, sort of the cornerstone of mediation is the voluntariness, as well as we ought not be forcing folks to pay for private mediation. So we had this situation, and because of this situation, the Trust and Estate section decided to figure out whether or not they had support. It had support for its proposal. It contacted the probate committee of the California Judges Association, of which I was a member at the time, and said, look, do you support our proposal, especially in light of the Geldwin case? And so what our committee did was canvass the judges throughout the state. And what we found, interestingly, was that after our poll is that the members were split and that there were strong opinions on both sides. As a result, the CJA, California Judges Association, probate committee declined to provide its support to the Trust and Estate section proposal. Our strong opposition was from the purists, or what I call true believers, that the mediation process would be harmed if it was forced on parties. So therein, lies, lay the rub at that time. What do we do? Let me go to the next slide. So in light of the Geldwin case, granting specific authority for judicial officers to force parties was not a good idea. It was too controversial, politically and otherwise. The result was the Trust and Estate section proposal was tabled. Now, we can stick with this slide for a second. What that did was it kind of chilled us on the bench. Those of us who thought we had the authority or should have the authority decided to sort of make references or referrals to mediation when we were able to get the parties or counsel to agree or stipulate, and then we would order or refer out. So you would go through the dance in the courtroom where you're suggesting mediation to counsel, and you're saying, counsel, if I get your stipulation or if you agree, then I'll order the matter out to probate. And so we would get it. Some counsel would balk because they weren't ready or whatever, and we wouldn't generally order it out. Some, judicial officers were more aggressive with it than others, but many just felt chilled and decided, to kind of leave it up to the lawyers to let us know if they wanted to go out. And so we didn't exercise authority directly. We decided that if we were going to try to get more mediation, the process that had started with courts developing their own panels, which had started even back in the 90s, we started to beef those up. Any rules that we had, local rules that we had regarding ordering out the probate, we deleted those things. So we did some internal changes because we were concerned that we didn't want to be, the judge who ordered something out to probate. And to mediation. And as it turns out, it was beyond our authority. And we did not want that sort of slap on the wrist. So there we were, back in 2006, 2007, retooling, referring, not ordering out, only getting stipulations to mediation, and kind of letting the chips fall where they may. I'll take the next slide now. But then 14 years later, this year, along comes Breslin from the 2nd District Court of Appeal. And many of you probably already know, if not all of you, the basic facts of Breslin, which are set forth in this and some succeeding slides. But basically, you had a situation where the question was, who are the beneficiaries of the trust? So a petition, was filed for instructions to determine the beneficiaries. There were roughly 24 potential beneficiaries. Some of them showed up they were all noticed of the petition for instructions. Some showed up at that court hearing, and some did not. At the hearing, the ones that showed up were told by the court that the matter was being ordered out to mediation, and none of those present objected. Let me go to the next slide. One of the potential beneficiaries who was present at the hearing decided it'd be a good idea to send notices to all 24 of the potential beneficiaries, and sent notice with these 5 essential components in the notice. And you can kind of read that for yourself if you haven't already, read it. Basically letting, these potentials know that we're going to talk about who's a beneficiary here and who's entitled to take and how the assets are going to be distributed. And you can show up with or without a lawyer. And basically, if we're giving you the date, the time, and the place, if you don't attend, you may be bound by this agreement, and you may not have a right to challenge. So all of that notice was given to all of the potential beneficiaries. A very important thing, by the way, the Breslin notice. What does it contain? What should it contain? And what I submit to you at this point is, it's the Breslin notice that is the true Breslin effect at this point. And that's the most important thing. But let's move on. I'll move on to the next slide. So they had their mediation, and settlement was reached. Once the settlement, not all the potential beneficiaries showed up. A settlement was reached. Only 5, actually, of the potential beneficiaries showed up. Settlement was reached. At the end of that, the trustee decided to, which is a good idea, to petition the court to approve the settlement, sent notice to all the potential beneficiaries. The no-show beneficiaries objected to the petition to approve the settlement. The court, over the objection, approved the settlement. And of course, these non-participating beneficiaries decided to appeal. What the Court of Appeal came out with, number one, they affirmed the trial court. And they affirmed the trial court on the basis of 3 points that the Court of Appeal panel made. First, they pointed to section 17206 of the Probate Code, where the Court of Appeals said that code gives the power to the court to establish the procedure in the judge's court or in that court. And as such, here, the judge established the procedure, made participating in the mediation a prerequisite to having an evidentiary hearing. And by failing to appear, the no-shows waive their right to an evidentiary hearing or to a determination of factual issues. So, in other words, the objection was an appropriate, the overruling of the objection by the no-shows was an appropriate decision for the trial court to make, and as indicated, affirmed it. Now, stay with this for a second. Stay with this slide. Now, section 17206, by the way, has been around since 1990. I mean, this is not a new code section. So why didn't we know about this power that was there back in, for instance, in 2003 when I stepped in 2006 when the trust and estate section, when Geldwin was around? Well, it's because if you read 17206, it's very generic and it's very general. And it doesn't really say anything about mediation. It basically, all it says is the court in its discretion may make any orders and take any other action necessary or proper to dispose of the matters presented by the petition. Very general, very generic. The Court of Appeal decided, Second District, that's enough. That provides the authority to the court to order out to mediation. A very interesting point. It's been there in plain view all the time. It's been there since 1990, but nothing specific in that to mediation. Okay, so there we are. And we have this decision, this opinion that seems to be very broad. And the euphoria then, the probate euphoria that I mentioned took over when this decision came out for those of us who believed that we wanted, judges or judicial officers to have this authority. But as I looked at the opinion, I became skeptical about how broad is the application and what problems might occur going forward with this decision out there. So I got a copy of the opinion, and let me go to the next slide. Let me tell you what I saw, because what I was looking for was more support for that decision, but what I saw gave me a great deal of pause and reason for concern. And there are 3 points of caution that I saw when I looked at these decisions. And I say decisions because there were 2. The first Breslin opinion was issued in January of 2021, and it was unanimous, the 3 justices. I mean, it was looking good. Everybody was on the same page. Everybody agreed. But then after rehearing on April 5th, 2021, the panel issued a superseding opinion that was significantly different from that first opinion. Now, the rehearing, I'm going to leave it to you to do the investigation as to why there was a rehearing. It can be at the motion of counsel. or it could be the justices sua sponte deciding, we want to, have a reconsideration, if you will, of that prior decision. However it happened, and roughly 2 to 3 months later, this superseding opinion came out, and the superseding opinion was substantially different in several different ways. 3. The first one is that now we've got a justice dissenting. No more unanimous. This was big. And what that justice said is imposing a terminating sanction against these no-shows at the mediation created an improper forfeiture. Oh boy. I mean, if there are some buzzwords, some negative words in probate, the word forfeiture is certainly one of them. I mean, that's what we're supposed to be avoiding. Remember the no contest clauses, et cetera, and all the litigation around that. And by requiring participation, this justice said, ignores the command that the trust be administered according to the testator's intent. Oh boy, another one. I mean, this is our first rule is to carry out the testator's intent. And by ordering out the mediation and allowing over the objection, the result that was done here is ignoring, the testator's intent. So that was one, what I consider to be a chink in the armor of this Breslin opinion. This now demonstrated a disagreement within the ranks of that panel, that 3-justice panel, and harkens back to what I indicated earlier when we did a poll of the probate committee of the California Judges Association, where we found significant differences, among the trial court judges. So let me go to the next slide.
Judge Whitley, I do want to point out that we have about 8 minutes left on the presentation.
I will zoom through.
Thank you.
Now, this next is the second point of caution. And I want you to be and I'm going to zoom through this, but this is very important. The earlier opinion, if you look at that second bullet point, the earlier opinion stated without qualification, when I compared these two opinions, the earlier opinion said a party receiving notice who fails to participate in court-ordered mediation is bound by the result. The superseding opinion, however, is a little different, significantly different. It says a party receiving notice, and then it adds this, under the circumstances here. So it adds under the circumstances here, who fails to participate in court-ordered mediation is bound by the result. So now this is a very limiting express limit on the application of their decision, an express limitation on the application of their decision. So we need to keep that in mind. And let me move on to the next one, the third point of caution. The third point of caution is that the superseding opinion added an entirely new paragraph that didn't exist in the first one. And what it says is that the no-show potential beneficiaries appeared at the initial probate hearing. No, had the no-show beneficiaries appeared at the initial hearing on the petition, for which they did receive notice, they would have had the opportunity to object to the mediation. And instead they waited until later to object. Basically what this opinion is saying is, it's saying that if they had been able to, if they had appeared, they would have been able to object and presumably prevent the order or the referral out to mediation. So if that's the case, that's nothing new. We had that authority before to order out as long as all parties who were present agreed by stipulation or agreement. So this seems to indicate that if you object to the order out, then you can prevent the matter from being ordered out to mediation. So I have a couple of slides here, and I know we have only a few minutes. left. So hit the next slide. So we do know that Breslin applies to its particular circumstances. I won't go through those again. You can read those for yourself, but the circumstances there. The next slide. What do we not know whether Breslin applies to? And number one, is it going to apply to any case that's not in the second appellate district? So that's a concern for those of us who are not in that district. And look at that dissent. It's a strong dissent, and it hits those buttons, the testator's intent, forfeiture, due process. The next is 17206, that gives the authority, that's trust. That's the trust section of the code. Well, what about the other sections of the code? And what about disputes? What about disputes that are trust disputes that are other than to determine beneficiaries? So we're in a problem situation here. I'm not sure that it's as clear as people think. We ought to get over our euphoria, go to the next slide. And what I am suggesting by this slide is to avoid the hot mess going forward and revisit this TexCom, this trust and estate section proposal in 2006 of adding a new section 1051, which makes a lot of sense to me. Take the guesswork out, and we'll be able to move forward without a lot of time being taken to figure out, what it applies to and what it doesn't. All right, that's it. In so many ways.
Thank you, Judge Whitley. In our last couple of minutes, I would just invite the panelists to address any final closing thoughts on any topics discussed on the Breslin matter. We had a couple of questions. I've made a note of them so we can follow up afterwards. But I opened the table to the panelists in our last couple of minutes.
And I've tried to answer some of the questions while listening to my colleagues, because I've done these before. So I hope some of those answers were helpful. Yeah, on the Breslin orders, because we're getting a lot of them in Orange County. A couple of my colleagues who are still on the bench say that they're just ordering everybody to mediation. I'm finding sometimes those are a lot more of a challenge to resolve if especially when you have super, super high conflict, which what probate case isn't. I mean, some are worse than others, but yeah, I just find it's a lot more helpful if they're there voluntarily. But I don't give up the ship or give up hope. It's just, I don't know what other people's experience has been, but in the last month and a half, the two most difficult to even get anywhere have been where they were ordered. And one of them, they've reneged because nobody wanted to sign a settlement agreement that day. And the other one, they gave up 3 hours into it, and they've been ordered now to something else. But I don't know if anybody else has any thoughts on that.
Bette, you're muted at the moment.
In San Francisco, because their pro bono mediation program provides 4 hours of free mediation, plus prep time is also pro bono. Those judges are very quick to order parties to mediation. And I find that oftentimes it goes way beyond 4 hours and it works. And here also in Northern California, Contra Costa County is also quick to get parties to mediation. And part of it is the culture of the court and what the lawyers who practice in those courts expect. I mean, I think in many of the Bay Area counties, at least where I work, the anticipation is that the judge is going to expect before you ever get to trial, you're going to go through a mediation. And the lawyers just know that that's going to happen. So we know that different courts have different cultures, but certainly in Northern California, that's pretty much the norm, is that you're going to spend some time in mediation before you ever get to trial.
Yeah, and I'm more of I'm in favor of even involuntarily moving cases out, and I do know that I'm in that group as opposed to the other group. I want to take kind of the culture out of it. I want to be sure that we do have that authority. I'm just not sure that Breslin takes us all the way, and that's my concern. I think that even if a case doesn't resolve completely, it tends to soften it to come into mediation. family law has been doing this for decades, forcing things out, particularly in custody and all of that. And I think that we look a great deal like family disputes. And so I just think it would be a good idea for them to come in. And it's a great idea if it doesn't cost them too much more. If we can get pro bono time, extra pro bono time, that's a good thing. But I do think that if you've sat there and you've had to decide these cases in trial for days and days and years, you sit there sometimes saying to yourself, as the judge who is hearing this evidence, why didn't they just go to some sort of mediation to resolve these disputes without coming in here and using not only their resources, but the court's resources to have to litigate this and have me come up with a decision when they could have fashioned something a lot better than what I could do. So I just think that, it's just something that probate needs to make as a centerpiece of its procedures. And that's why I like what TexCom came up with back in 2006, and I'm still trying to push it forward.
And I hate to cut you off, but we are at the end of our timeline today. I would just like to reiterate to all of our attendees, thank you so much for attending today. You will receive your MCLE credit certificate via email this afternoon, so keep an eye out for that. And if you don't receive it, please contact me, Katie, Katy, at adrservices.com. As soon as you close out of this presentation, you'll be taken to a short survey screen, and we would really, really appreciate if you take a few minutes to respond to those questions. One that I'd especially like to bring your attention to is an opportunity to offer future topics for our Trust and Estate panel to discuss in future webinars. This will be one of a series of webinars based off focusing specifically on trust and estate and probate issues. And our panelists would love your suggestions on future topics. So keep an eye out for announcements for the next date in the series as well. And finally, I would love to thank all of our presenters today, Judge Schulte, Judge Johnson, Judge Whitley, and Ms. Epstein. Thank you so very much for your time and sharing your expertise with us today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.